Well, employment is all good fun until, as they say, somebody loses an eye. And so one of the sort of dominant issues about employment is when issues and problems arise. So that's what we're going to move on to now. Employment problems and personal grievances. Employment law recognises that there will occasionally be problems that arise in employment relationships, and the Employment Relations Act therefore requires that employment agreements that are made between employers and employees include clear guidelines as to how to proceed if a problem arises. Section 103 of the Act sets out the criteria or grounds for employment problems being dealt with as personal grievances. So a personal grievance is a particular category of problem. And the grounds for personal grievance are unjustifiable dismissal, unjustified disadvantage, that is missing out on something or being treated unfairly, that you're still an employee but you've been hard done by in some way, or being discriminated against or mistreated or harassed sexually or racially or on the basis of union membership. So they're all set out in section 103. And there are also established rules about how to deal with personal grievances. One of the first things to note is a timeline. There is a strict 90-day deadline that starts ticking from the moment a grievance is experienced, or an alleged grievance is experienced, where an employee needs to raise that with the employer within that 90-day deadline. They can be dealt with outside the 90-day deadline, but only if the employer agrees to it, and I can't imagine any circumstances where they would. So if something happens and 90 days passes, it's time's up and it can't be dealt with through these personal grievance procedures. Sometimes things can be just sorted out amicably by way of a conversation and some sort of resolution between the employer and the employee. But where things are a bit more serious than that, there is a free mediation service that's available for resolving personal grievances. And an estimated 80% of employment problems that are referred to mediation are resolved in mediation. This often actually doesn't mean that it's just a handshake and it's all over. It does often involve settlements that include compensation payments, but these are almost always confidential. But it's a good service. It doesn't require lawyers to be involved in it. It's a neutral ground for getting things resolved, and it's pretty successful in its ability to resolve most employment matters. Where things aren't resolved through mediation, then it moves on to the Employment Relations Authority that will conduct a hearing and make a judgment. The advantage with mediation is that it's only settled when both parties are happy with it. If one party isn't happy at mediation and wants to take it further, that ability to find something you're happy with is lost, because the Employment Relations Authority then hears the cases and makes that judgment, and that judgment is then binding. So it's a bit of a risk moving it on beyond mediation to the Employment Relations Authority. Where a party contests the authority's ruling, they may appeal to the employment court. These are contests over points of law. They're not generally arguing the ins and outs of the case. They're interpretations and application of the law. That's where appeals go to the employment court, and then beyond the employment court, appeals against judgments of the employment court go right directly to the Court of Appeal. So that's the kind of legal process for dealing with these employment problems that turn into that take the form of personal grievances. What are the remedies for personal grievances? Well, Section 123 of the Act provides 4 broad remedies for personal grievance, any one of which or all of which could be applied. So these are reinstatement of employment where there was a dismissal. That used to be the preferred option, that basically everything was aiming towards reinstatement unless that wasn't possible, but that's been altered now. So that's one of the options, and it's recognised that there are lots of circumstances where reinstatement wouldn't be in the interests of either party. Reimbursement of lost wages, salary or other money. So where, for example, a dismissal was found to be unlawful and the person who was unjustifiably dismissed ended up in no work for a period of time or working for less money, then the consequence of the unjustifiable dismissal is that lost wages, and so that can be claimed as well. Although there is an expectation that you can't just, once you've lost your job, sit there and not do anything about it and think, oh, I'll get this money from the employer. You need to demonstrate that you have actually taken steps to find alternative employment as well, or you can limit the amount that you will be awarded under lost wages. And then there's this category of compensation for injury to feelings, which sounds a bit kind of touchy-feely, but that's essentially the making up for the wrong that was done through an unjustifiable dismissal, and that's the term that's used in the legislation. And there is a sort of an assumption that where there is an unjustified dismissal, then that is a wrong that needs to be put right, and it's put right by payments of compensation. The amount of which depends on the egregiousness of the action that was taken against the person, the unjustifiable action, and all the other circumstances around that. What sort of salary the person was on, what sort of seniority, the seriousness of the injury, and so on. So there's those compensation figures, and then there are also recommendations of actions that the employer should take, and this is particularly in relation to situations where there's been sexual or racial harassment. So the most common form of personal grievance is unjustifiable dismissal. In fact, 80 to 90% of personal grievances relate to allegations of unjustifiable dismissal. So I'll be discussing these in a bit more detail. The main categories for personal grievance over unjustifiable dismissal: misconduct, poor performance, and redundancy. And so in the next video I'll go into more detail about what's involved with these personal grievances over misconduct, how issues of misconduct can be dealt with in a way that are lawful and not opening an employer up to claims of unjustifiable dismissal.